Sir, if you please take the stand. Counsel for the state, whenever you're ready.
Thank you. Good afternoon, Sergeant. Can you please just introduce yourself to the court?
Yes, Sergeant Douglas McBride.
And where do you currently work?
Phoenix Police.
And how long have you been working there?
26 years.
What is your current job assignment?
I am a downtown operations training sergeant / grenadier sergeant.
Can you explain to the court what exactly is a grenadier sergeant?
I am basically in charge of all of the non-lethal grenadier munitions that are deployed during civil unrest when those crowds of people turn into rioting and destroying property.
All right, and how long have you been doing that?
Coming up on 4 years.
Back on October 17th of 2020 at approximately 7 o'clock p.m., were you working?
I was.
Were there other officers that were working?
Yes.
And with regards to the particular investigation we're going to be getting into, were there reports that were written relating to this investigation?
Yes.
And so were there other officers that were involved?
Yes.
And is it the policies and procedures of the Phoenix Police Department for officers to come to court and testify when subpoenaed?
Yes.
So all of the officers that we're going to be discussing today are available to come to court and testify if needed?
Yes.
All right, so this particular investigation, did it involve 18 individuals, 18 individuals that were arrested?
Yes.
And did this occur within several different areas within the downtown Phoenix area?
Yes, it did.
And is that downtown Phoenix area, is that located in Maricopa County?
Yes, it is.
One of the individuals that we're going to be talking about today on Savannah Ratnam.
Yes.
Do you see that person in the courtroom today?
Yes, she's seated to my right wearing an orange jumpsuit. She's currently in a blue mask and writing on a piece of paper.
And prior to October 17th of 2020, were you familiar with this particular defendant?
Absolutely.
How did you become familiar with this particular defendant?
On a prior occasion, she was involved with throwing water bottles at police, and she ultimately stabbed a sergeant in his hand with an umbrella tip.
And the information about the water bottles and things of that nature, and your knowledge of this particular defendant, did that come into play with regards to your tactics and what you did on October 17th of 2020?
Yes.
And with regards to your previous knowledge, did you have knowledge back when she stabbed the Phoenix officer, was she found with certain items?
Yes, she was.
What items was she found with?
Objection is relevance, Is that relevant?
Judge, it goes to the relevance as to the current charges and why the officers acted the way that they did with regards to rioting in this case.
Well, it'd be relevant if she stabbed somebody in this incident, but it's not even alleged. So I don't know how that's relevant. It's prejudicial.
Sustained.
Well, with regards to the information that you had, did you utilize the information based on this, what you knew about this defendant on October 17th, 2020?
Yes.
Right. So on October 17th of 2020, let's get into that investigation. Can you explain to the judge, where did all of this begin?
It began at 10th Avenue and Van Buren. There's a park on the north side of Van Buren where the group said they were going to assemble.
And approximately what time did the group assemble at?
It was about 7:30 that they started coming into the park.
And at some point...
Sorry to clarify, AM or PM?
It's a nighttime PM, sorry.
After this group assembled, were you guys there waiting for this group to assemble?
We were staged.
How did you guys even know that this group was going to be there that day?
There was intelligence through social media and other networks that said that they were going to meet at that park at that time.
All right, and so when you say that you were staged, what exactly do you mean by that?
So typically for these types of events, we have a multitude of officers and resources just in case it turns into a riot. So we stage them 360 degrees kind of around the area, depending on where the group would go. we don't necessarily know where they're going to go, so we'll stage resources so we can deal with them no matter what direction they head out in.
And so did this group stay within the confines of the park?
They did not.
Where did they go?
They immediately flooded out into Van Buren, West Van Buren Road there, and completely took over the entire street, blocking traffic, and dozens of vehicles had to be rerouted for their protection as well as the vehicles' protection.
And when these individuals entered the street, or even prior to that, were they yelling or saying anything?
Yes, they were.
What were they yelling or saying?
I believe it was A, C, A, B, and then the group would respond, all cops are bastards.
Right, and with your dealing with this particular defendant as well as ACAB, do you know where that came from?
We have been dealing with it since May. Since these protests started, it was a specific group of individuals that identified themselves as being part of All Cops Are Bastards, or ACAB.
All right, and so these individuals, they get onto the street and they start, you guys have to reroute traffic. Do they stay out in the street kind of like in a group, or do they go somewhere?
Well, they stayed out in the street and continued to move through the downtown area in the middle of the roadways.
And what happened while they were moving down through the downtown area?
As they were moving, they continued to chant. They utilized large umbrellas to surround the outside perimeter of the group so we couldn't see what they're doing. Ultimately, at about 3rd Avenue in Washington is when we saw 3 incendiary devices thrown at 2 of our police cars.
And what do you mean? Can you describe what you're talking about?
So these canisters, they're large canisters of that emit a large amount of smoke, probably 30-foot plume of smoke each one. They threw them at the 2 different vehicles that were following to keep tabs on the group. This type of smoke and emission covers the visual ability of the officers. It's very difficult to see through this thick smoke, which then enabled them to grab barricades from the construction sites and place them in the roadway, which ultimately disabled one of our police cars because we couldn't see what they were doing at the time.
Just foundational, just how many of
Is
these
there an
devices?
objection that you're making?
Well, I didn't hear how many. Yeah, objection, just clarification. I don't know. How many devices is he saying that were deployed?
How many of these things were thrown at the police officers?
As I just stated, 3 were thrown at 2 of the trailing police vehicles.
And these trailing police vehicles, were there only police officers that were located within the vehicles, or were there police officers outside the vehicles?
So both, we had police officers on foot as well as inside the vehicles at the time.
And with regards to the officers inside the vehicles, as well as the officers outside of the vehicles, were they concerned for their safety?
Absolutely.
And why is that?
These particular devices burn at about 700 degrees Fahrenheit. They're extremely flammable. We didn't know, there's no way of us telling if it's just smoke or if there's other chemical munitions in that smoke as well. So it's a hazard, number one, from a sight situation, being able to see what's going on, but also there's the fear of there being a chemical in there that we may ingest as well, because frequently it's in a CS type of environment. So because of the heat, it can light things on fire. Several of my grenadiers had to get out and deal with those devices to get them to a safe place so they wouldn't catch anything on fire, get them out of the roadway so they have the ability to melt tires on vehicles and all that stuff as well.
And recognizing the danger of these things, however, did officers still have to act upon what they were seeing and still continue to do their job?
Yes.
Section vague.
Overruled.
And with regards to that particular, leading to the next question, with regards to acting on their jobs, did one of the officers actually have to get out of their vehicle and remove one of these incendiary devices?
Yes, he did.
All right, and so after these incendiary devices were thrown, did the group continue to walk down Washington?
Yes.
And
continue to grab construction barricades from all around the area and place them into the middle of the roadway and attempt to disable our vehicles.
Did you guys, did officers at any point have to stop their vehicles in order to get out and remove the barricades so they could continue down the road?
Many times.
And at some point, you guys get closer to the light rail tracks.
Yes.
What happens at that point?
At the time, my Lieutenant Benjamin Moore, serial number 6803, he was one of the lead vehicles behind the group. They had their windows rolled down in their Tahoe, and they heard the group say that they were going to take the light rail track system over. And there was an actual light rail that was on it was southbound on First Avenue at that particular moment. You could see it in the distance. So he heard that statement.
And what happened when the officer started to converge onto the group?
The group surrounded themselves with umbrellas to conceal what they were doing, and most of them laid down on the sidewalk at First Avenue and Van Buren, interlocking arms and legs to prevent apprehension.
And when the officers went to move in to try to contain these individuals, did some officers become injured?
Yes.
And I'm going to talk about specifically about you. Did you help go in and try to arrest these individuals?
I did.
And did you become injured?
I did.
And what happened?
The individual, I believe it was later identified as Dominic Benelli. He utilized a tactic when I reached in to separate his hands, which were interjoined with another individual's hands, where they dig their fingernails in the back of your knuckles and try to disable your fingers and thumb. My particular thumb was affected. It damaged it, and I had some soft tissue damage as well as a lot of blood.
So did he cut you with his nails?
Yes.
And when you stated that this was a tactic, what do you mean?
With these particular groups, they try to make it as difficult as possible for us to arrest them. They try every tactic they can to protect each other from the police and inflict as much pain as they can on us while we're trying to effect an arrest.
Now, the responses that you guys utilize during these protests or whatever, does that also include giving commands?
Yes.
And from the beginning of this, were there commands that were given once these individuals entered into the public roadway?
Yes.
Can you explain to the judge what kind of commands were given?
So as soon as they entered the roadway at 10th Avenue and Van Buren, two Phoenix Police Tahoes equipped with the speaker announcement system, the PA system on the front of the vehicles, pulled up directly behind this group and began telling them that it is unlawful to obstruct a thoroughfare. If they continued to do so, they would be subject to arrest. I believe it was repeated over 32 times that evening while those vehicles were traveling behind the group and warning them to get out of the roadway.
And while you guys are traveling behind, I'm sorry, let me clarify something. When all the arrests were happened, were you guys able to identify the defendant as being part of this group?
Yes, we were.
And was she arrested during the same time as everybody else was arrested in the big group?
Yes, she was.
And as you guys are following it down behind these individuals, giving commands, things of that nature, are there ordinary citizens around in the area?
Yes, so downtown is operating, everything else is operating as normal. I mean, there's construction crews, there's restaurants that are open, there's ASU students walking around who are having to be diverted or blocked off from going in the area as they move through the downtown area.
And with regards to people on foot as well as people in their vehicles, were they substantially affected by what the defendant and her friends were doing?
Yes.
And
well, foundation speculation.
Are you objecting?
Yeah. Objection. Foundation speculation.
And what
Who was this?
foundation?
Who was this person that was affected by this? It's just generality. It's improper testimony.
Counsel for the state.
absolutely, Judge. Sergeant, you just stated that as part of what you were observing, you personally observed this, correct?
Yes.
Of what you were observing vehicles that had to be diverted because of the defendant and her friends being in the roadway.
Does it? Yes.
Okay, and affecting their everyday travel.
Yes.
And the ASU students, you stated that there were ASU students that were knowing about that they too had to be redirected on changing their direction of path. You saw this.
Yes.
All right. And with regards to this whole entire thing, was it caught on several different forms of video? Video.
Yes.
Did that include body-worn camera by the officer?
Yes.
Did that also include surveillance video attached to vehicles that can actually, record and travel down with these streets?
Yes.
And with regards to these videos, was there a compilation of different body cams, including your own, that was used in order to aid in understanding what was going on back on October 17th of 2020?
Yes, there was.
So that back to the objection on foundation. The court feels that enough has been given through testimony, therefore the objection is overruled.
Right. With regards to the video, have you had the opportunity to view it?
I have.
And is it a fair and accurate depiction of several different videos put in kind of like a time sequence to better explain what was going on that night?
Yes.
All right, and I'm sorry, fair and accurate, correct?
Yes.
Now at this time, the state would move exhibit number 1 into evidence.
Counsel for the defense.
I don't object. I just to clarify, if the state could have the officer clarify that, I think he said it's a compilation from various officers. So as long as the court understands that it's not one officer, it's just a bunch of different ones.
Counsel for the state.
Is that correct? Is a compilation from different officers, different videos that was taken from this night?
Yes.
Okay.
You're asking to move that into
Yes,
this
sir.
evidence?
Yeah, I don't object.
Okay.
The state showed me sanction.
All right. So which exhibit is it?
Exhibit 1.
Exhibit 1 is now admitted into evidence.
And may I publish to you?
You may publish it to me.
All right, so Sergeant, I just put the video up here, exhibit number 1. Now, do you recognize, is this the video, part of some of the videos, part of the body-worn camera we're going to be talking about?
Yes.
Okay, can you explain to the judge, what is she saying here?
So this is the group of individuals we have been previously talking about, Your Honor. They're in the middle of the roadway. I believe this is Washington Street, one of the major arteries in the downtown area. They're actually going counterflow on Washington, so you can see down in the distance headlights of vehicles that are either being diverted, stopped, moved to the side because the crowd is moving in their direction. Extremely dangerous situation here.
So with regards to, just to clarify, here we can see a police Tahoe off to the left of the turning right left, and then we see these vehicles over here. Are these police vehicles?
No.
All right, and are some of those the vehicles that had to be diverted in order to, because of because of the defendant and her friends?
Correct.
All right, so this video, are we taking a look at this particular clip? Is this body cam, or what is this?
This is, so Your Honor, this is a camera system that's mounted to the back of a pickup truck and just allows, it doesn't have any audio, but it can just zoom in and zoom out to take better, clearer large group photos than just a body camera on an officer's chest.
All right, I'm going to go ahead and let it play. And the umbrella, have you seen this tactic used in the past?
Yes.
And is this a tactic that's commonly used with regard to this particular group?
Yes, it is.
Now, as they're walking down Washington, are they still yelling out the ACAB, all cops are bastards thing?
Yes, and there's your first munition that was just thrown from the center of the group.
So that's not from you guys?
No. As you can see, it totally conceals the group there. And there's the other one.
Now, at this particular moment, how many munitions did they use at this particular time when they're walking down the street?
I believe it was 3 at this location.
And as of right now, we're seeing the 2. Now, is that correct? The 2?
I think the third one was off to the right, but yeah, I mean, there was definitely 2 you could see.
Okay. And
Ms.
here,
Sponsel,
now,
I hate to interrupt you.
No, you're
Could
fine.
you rewind it just a little bit so we can see the second one that the officer is speaking about?
Sure. Okay, so
It's a little further back.
let me go.
That should do it. So I think that's the first one. And as it pans to the right, you're going to see the second. There's the second one.
Okay.
And but you said that there was 3. Is there?
And that's what it looks like right there. There's another plume of smoke kind of out of the camera's view, closer to the camera. So that's probably the third one.
Okay, and now we've transitioned from that. I'm sorry. What did you say? Did you say strong watch?
Yes, the camera system on the truck.
The camera system on the truck to it looks like what have we transitioned to?
One of my grenadiers' Officer Christopher Turiano's body camera is now what you're looking at. Your Honor.
Okay. And I just want to go back just a little bit. When he gets out of the vehicle, because it appears as though it's kind of backed up just to coincide with his, do you actually see the munitions being thrown in his?
Yes. So if you play it through the windshield, I believe, before he gets out. So there's his one. You see, that's the first one, that dark black thick smoke, and you see that flame. You see that flame pop right as he's looking through his windshield there.
And then there's a green one off there.
Yes, there's that green one.
All right, now we're transitioning to what portion of the video?
This is where they're continually grabbing all of the construction signage, everything that they could find on the sides of the road that's there to protect people from falling in the construction zones. And they're pulling them out deliberately in the middle of the street, working together as a group to block our vehicles, disable our vehicles, in an attempt again to create distance between the group and the police vehicles that are following.
Now, Sergeant, I'm going to pause it here just for a second. And Judge, just for the court certification, the video is about 8 minutes long. It's not too long. But how long have you been working down in the downtown operations dealing with protests and riots and things of that nature?
Just about 4 years coming up on. Actually, it's 4 years right now this month, yeah.
And have you had the opportunity to work both on peaceful protests versus riots?
Absolutely.
And are you able to tell the court in your training and experience what the difference from what you have seen relating to a peaceful protest versus that of a riot?
I'm going to object. He hasn't been noticed as an expert, 1. And 2, it's not relevant to rioting. I mean, the rioting has a definition. The court can make its own determination. They can't use him as an expert to say this was a violent protest. That's the ultimate fact here, Judge. So I object to this testimony.
Counsel for the state.
Judge, we're not asking him for an expert opinion. We're asking him for in his training and experience, what he has experienced in the past with regards to those that are not throwing things at them versus individuals who are throwing things at them.
Well, that's not relevant, Judge. I mean, the court has to determine whether or not, if these devices were thrown, whether that constitutes riot. That's what we're here for. What happened in the past is not relevant to this proceeding.
The objection is sustained.
Well, with regards to these particular individuals that you've been working for a while now, did anybody give them permission to throw any of these items at the officers?
No.
Did anybody give them permission to go out and block traffic?
No.
Did anybody give them permission to throw out barricades out in the middle of the street?
No.
And what are we seeing here?
Again, this is body cam footage. I believe it's Officer Turiano again. He's on foot with several other grenadiers protecting officers who are attempting to get the barricades out of the street at this point.
Did that allow the group to get further away from you guys at that point?
Yes, as you can see, they're quite a ways down now, over a block. We're trying to catch up, but it's just difficult.
Now, what is the court seeing here?
This is at the time when my lieutenant heard them say they were going to take the light rail train tracks, which are they're actually right where this camera truck is filming from. He's basically just east of the tracks. The tracks are right there. They run on north-south on First Avenue, and this is Van Buren. And you're seeing the 18 individuals that we had been following. They kind of hunkered down with the umbrellas there, right at that railing on the northwest corner of First Avenue and Van Buren Street.
And so, because of the compilations and stuff like that, do we actually see in other footage of these guys going and just literally going down to the ground?
Yes.
All right.
Most of them.
Now, did you see that puff of smoke that just came out?
Yes.
What is that?
Another incendiary device.
And who set that off?
Someone in the center of the crowd.
For the police or for the defendant and her group?
For the defendant, one of the defendant and her group set that off.
Now, right here, who is that is talking?
That's my lieutenant, Benjamin Moore, that I referred to earlier. That's his body camera.
And is he the one that authorizes whether or not you guys are going to perform arrests?
Yes.
And did he put out previously that they had stated that they were going to take the tracks, or was that relayed to you guys in any way, shape, or form?
I'm not sure. I'm not sure if he put it out on the radio or if he told us afterwards. I don't remember that part.
Okay. So, but at some point, he's made the decision that you guys are going to go and arrest these
Yes.
individuals, including the defendant.
Yes.
And what are they doing with their umbrellas right there?
They're keeping them between us and them, and they're swinging them back and forth to basically distraction, to conceal what they're doing, because there's just trying to prevent us from arresting them.
And what are you guys doing at this particular moment?
There's an individual in the back, and I believe they slow it down here in a second, but he's on the railing, and he's trying to climb over the railing to throw something at the some of the grenadiers that are on the back side of this group. So he keeps trying. He's not complying. He's the one that didn't get down with the rest of the group, and he's engaging two of the grenadiers on the back side.
And the defendant is in this group, refusing to give up and go peacefully.
Correct.
Everybody down! Get on the ground! Get on the ground! Get on the ground now! Get on the ground! Get on the ground! Get on the ground! Get on the ground! Get on the ground!
This is just another view.
Yeah, it's just another angle. I don't know whose officer's body camera this is.
And what are we seeing here?
That's a slowdown, Your Honor, of the gentleman on the railing that I was speaking about. And you'll see when they slow it down, they'll actually show him he's reaching he reaches with his right hand into the backpack, brings something out, and is about to throw it at the officer. And that's when one of my grenadier hits him with a few pepper balls. Yes, I don't know what the object is. We did not recover it, but he definitely has something in his hand. And then the grenadier addresses him.
And what is the grenadier shooting him with?
It's a pepper ball. It's the easiest way to explain is it's like a paintball capsule, but it's filled with pepper, like hava is what they call it, which is just it disrupts your airway. Sorry, get it right. It disrupts your airway and your vision.
And did the grenadier know that this was happening at that point? That he was pulling this item out and swinging, or getting ready to throw something. Did he have any idea what was in that individual's hand?
No, not that I know of.
All right, and let's go ahead and watch this view. Explain to the court what exactly is happening here.
So that's me. That's my shoulder in the video. I'm trying to get their hands apart, and that's where I ended up getting cut in the back of my knuckle. But I'm trying to just basically pry their hands apart with brute force, trying to break their grasp, and they've all been told that they're under arrest, and they're not allowing us to do that.
And are they holding on to each other in this view?
Yes, you can see their feet are interlocked, their arms are interlocked. 18 people interlocked together makes it extremely difficult and hazardous for us to effect an arrest.
All right, now I want you to focus in on this person right here.
Yes.
Do you know who that is?
Yes. Extremely. This is the individual, I believe, that. Is it that one?
Well, was one of those individuals there armed with an AR-15?
Yes, I was just trying to verify. So there was one individual, we knew that prior to the arrest, that was armed with an AR-15 and had it slung the whole time that they were marching around downtown.
And what is that officer holding?
That's the AR-15.
And when we saw that individual was originally sitting down when officers first came up, where was that AR-15 at that point?
It was slung around that individual in the front of her body.
And what's happening here?
That looks like a magazine for the AR-15. individual also was armed with a Glock handgun.
All right, and with regards to these particular individuals, after you guys were able to get them in custody, did you talk to any of these individuals and learn where the incendiary devices came from?
Yes, we did.
And where did they come from?
The defendant.
And when you guys went and
well, I'm gonna object. I'm gonna strike that. Like, who told him that? I object to that. Where were they obtained? It's improper testimony.
with regards to your investigation and arresting you guys also take backpacks and found several different backpacks in this room.
Yes, we did.
Did you guys locate any items of concern in the backpacks?
Yes, we did.
And what did you locate?
We located rocks, bricks, matches, multiple cans of spray paint, accelerant fluids like lighter fluid, obviously the umbrellas, which are another hazard for us. Off the top of my head, that's the best I can remember right now.
All right, and with regards to was there a bullhorn that was also located?
There were several bullhorns, yes.
And did one of those bullhorns, could it open up and have like canisters inside of it?
Yes.
Okay. And were there more incendiary devices located in that particular bullhorn?
Yes.
And throughout the night, did you guys continue to give command after command after command for these individuals just to stop?
Yes, we did.
Just to get out of the road?
Yes.
And they didn't follow any of that?
Correct.
Now, the damages, you say that one patrol vehicle obtained damages caused by running over the barricades. Was that one of the barricades that was thrown out in the street by the defendant and her friends?
Yes, it was.
And was there any of these barricades that, with regards to property damage, were any of these barricades damaged?
Yes. Several of them, the lights were smashed and they were bent and left in the roadway.
Your Honor, may I have a And Sergeant, just really quick. Now, when you guys were doing the processing of all of the individuals that you arrested that night, specifically the defendant, had you learned that she was on release pending another felony offense?
Yes, we did.
And was that felony offense the one with the umbrella where she sliced the officer's hand?
Yes.
Your Honor, that's not relevant to this hearing. I'm sure Ms. Sponsels provided court with certified documents to show that.
Overruled, counsel.
All right, I have nothing further.
Counsel for defense, cross.
Did you charge Ms. Ratnam with resisting arrest?
No, sir.
Do you understand this bail hearing is not for resisting arrest, right?
Yes.
Okay. So you spent a lot of time talking about people resisting arrest, but Ms. Ratnam is not charged with resisting arrest, correct?
Correct.
All right. And you spent a lot of time talking about an unlawful assembly, people walking down the street, correct?
Correct.
You realize we're not here for a bail hearing regarding unlawful assembly. You understand that?
Correct.
Okay. You testified a lot about obstructing a highway, which is a misdemeanor offense, correct?
Correct.
We're not here to talk about obstructing a highway in terms of bail hearing, correct?
Correct.
All right. So we're here to talk about the charge of rioting. Do you understand that?
Yes, sir.
Do you understand what rioting is?
Yes, sir.
All right. Now, with regard to Ms. Ratnam, you said there was an individual with an AR-15 at the scene that day, correct?
Yes, sir.
All right. Is there anything illegal about having an AR-15?
No.
Okay. Was that person a prohibited possessor?
Not to my knowledge.
Okay. Did that person ever point an AR-15 at any officer or threaten to point an AR-15 at any officer?
Not to my knowledge.
Okay, so you would agree with me then that AR-15 did not calculate into your factoring of charging of rioting, correct?
Correct.
Because you didn't know about it until you arrested this individual, correct?
No.
All right. And you have no knowledge that Ms. Ratnam gave somebody or had an AR-15 on her person, correct?
Correct.
All right. Now, you talked about incendiary devices being used at this particular incident, correct?
Yes.
I'm a little confused. You have military experience?
No, sir.
Okay, I don't either. But you have law enforcement experience, so you have more experience than I do. My understanding is an incendiary device is a device that's used to create a fire or ignite something. Am I wrong about that?
Well, it's anything that produces flame, heat, related, combustible.
Right, like napalm,
That's a drastic example.
phosphorus, or things of that nature, correct?
Okay.
All right. These particular things that were deployed were smoke devices, correct?
Yes.
Okay. Now you have to light them for them to create the smoke, but they were not designed to ignite anything or inflame anything, correct?
That's hard to answer.
Why is it hard to answer? Did you
Because there's a
collect them?
large, well, as you saw in the video, there's a large flame and they burn for a very long time at a very high temperature. So they absolutely have the capability to light. Like I said earlier, they could melt tires on a police car.
Okay. But in this particular instance, we see smoke, correct?
Yes.
All right. Now, did you see Miss Ratnam throw any of these devices?
No.
Did you talk to her after this incident?
I did not.
Okay. Do you have any evidence that she herself directed someone to throw these devices?
Just co-defendant and co-defendant interviews.
Okay. And you have any personal knowledge or any evidence that Ms. Ratnam, did you find out where these items were purchased or anything of that nature?
No, sir.
Okay. And these individuals who you interviewed, in your experience when you interview people have a tendency to minimize their responsibility and their actions, correct?
Yes.
So it's possible these people fingered other people to try to absolve themselves from responsibility, correct?
Yes.
All right. Now, so we talked about the weapon. That wasn't a factor in the writing charge. We talked about the devices. You didn't see Miss Ratnam throw any devices, correct?
Correct.
All right. You didn't see Miss Ratnam. You have no evidence that Miss Ratnam somehow encouraged others to do that, correct?
Other than co-defendant interviews.
Okay. Which you acknowledge that those lack credibility at times, correct?
At times.
All right. Now, so let's talk about, I think the other thing you talked about was these pulling or taking barricades or moving items into the street.
Yes.
Okay. Did you see Miss Ratnam do any of that?
No.
Okay. You reviewed all those videos, correct?
No. I did not review all.
Okay. You reviewed the video of the Miss Sponsel.
My body-worn camera and that one.
Okay.
And several others.
In the video we have today, we don't have any evidence of Miss Ratnam actually moving barricades into the street, correct?
Correct.
Do we have any evidence of her directing others to move those into the street?
Other than co-defendant interviews.
Prior to this march, did you hear Miss Ratnam make any threatening statements towards anyone?
Not that I recall.
Okay. Did you hear her at any point in time, did you see Miss Ratnam use force against anyone?
No.
Okay. And you never saw Miss Ratnam remove barricades herself, correct?
Correct.
Now, while they were marching down the street, at any point did police fire things at the group?
No.
Okay. They didn't fire non-lethal weapons at them at any point in time?
Nothing was deployed while they were walking.
Okay. When they went to the at some point they went to the sidewalk, correct?
At the arrest, is that what you're?
Yes,
Yes.
at the arrest. All right,
Yes.
that's better. The only person I saw in the video standing up was an individual who got somehow, I don't know if it's pepper sprayed or he got sprayed with something, correct?
Yes.
Was that Miss Ratnam?
No.
Okay. Did she injure any officers? Dig her fingernails into any officers?
No, sir.
Did you see her interlock her fingers or arms? Did you personally see that?
I did not personally see that, no.
Now, you said that this group was yelling, all cops are bastards during this protest, correct?
Yes.
I watched the video. Didn't they say other things during the time they were walking down the street?
I'm sure they did.
Okay, because I guess I was. Did you hear him say Black Lives Matter?
Not personally, no.
Okay. Well, did you watch the video with sound on it?
Yes.
Okay. And you didn't hear him say Black Lives Matter during any point of this time they're marching?
They may have. I'm not saying they didn't.
Okay.
I just don't have an independent recollection of them saying that.
So as you sit here today, you agree with me, you have no testimony that is clear proof that Ms. Ratnam was there to participate in violence, correct?
I would say I do have proof.
Specific to her?
She was in the group.
Okay. So you're taking the actions of individuals in the group and imparting it onto her, correct? That's your testimony.
Well, the entire group worked together the whole time.
Well, what specifically did Ms. Ratnam do? What did you see her do on the video? What did she do? You didn't see her point a weapon at anybody, did you?
No.
You didn't see her throw devices at anybody, did you?
No.
You didn't testify about specifically having knowledge of throwing these things at individuals, correct?
Correct.
You didn't see her pull a barricade down, correct?
Correct.
You didn't see her directing people to pull a barricade down, correct?
Correct.
Would you agree with me those umbrellas are used for them to protect themselves from being pepper sprayed?
That's one example of use.
All right. So they have other uses that you've testified about, but you agree that the group will use umbrellas to avoid being pepper sprayed. Is that right?
That is one application, yes.
So, in essence, your testimony is Ms. Ratnam's in this group. There are individuals inside of that group with certain things, and therefore she's part of that group. Correct? That's your testimony today, correct?
Can you repeat that, please?
Your testimony is Ms. Ratnam was in this group, correct?
Part of the group, yes.
There was individuals in the group who did some things that you have no knowledge that she was aware of or directed, correct?
Correct.
But she was in that group, and therefore she's part of the group, and therefore you believe she was directly involved in these actions. Is that correct?
Correct.
All right. No further questions.
Any redirect?
Yes. So let's start off with one of the last questions that defense counsel asked you, and that is on other applications of the umbrellas. Other than to use them as a deterrent from your guys' ability, your cover balls and stuff like that, how else would they use them?
They're used to assault officers. They're used to conceal criminal behavior, i.e. throwing munitions, moving barricades, obstructing visual fields of officers' vantage points to basically gain an advantage over law enforcement to commit criminal acts.
And when you guys went up to finally get these individuals into custody because they were yelling, "Let's take the tracks," you testified that they were using the umbrellas to swing them. Is that a common practice to use force against the officers so they can't arrest these individuals for other crimes?
Yes.
And is that what exactly that the defendant and her friends were doing?
Objection, Your Honor. Yeah, that's a compound question. If he wants to say my client, he saw my client do it.
Judge, these defendants...
And it's not relevant because she's not being held for resisting arrest. She's being held for rioting. That entire course of conduct on the sidewalk is completely irrelevant to this hearing. Either they're charged with resisting arrest or they're not. They decided not to. So it's not...
If you rephrase the question, please.
I'm sorry, Judge, what question?
If you'll rephrase the question regarding I think you were talking about the umbrellas and the use.
Yes. What were they doing with the umbrellas when you guys walked up there?
Objection, compound question, relevance as to they, Your Honor.
Overruled.
Okay. Sorry. They're using them to prevent their arrest.
And this is, and the, let's say, one person, were you able to identify one person to say, hey, that person had the umbrella?
Not in this group, no.
And why were you unable to do that?
Because they utilize that black bloc clothing, that type of outer layer of clothing. And what it does, Your Honor, is it makes it difficult to tell whether they're male or female. I mean, it's very difficult to identify them. Their entire face is covered, usually just the eyes. Everything else is covered, and it's very androgynous, if you will. You cannot specifically say that's so-and-so or so-and-so until after we peel the layers back and we're able to say, oh, and, you know, we immediately recognize the defendant at that point because we had had interactions with her before.
And was she one of the defendants that was interlocking, which is down on the ground, interlocking, and not allowing you guys to arrest?
Objection, asked and answered. Didn't see it.
Overruled.
That is my understanding based on the officers out there. Every single individual, with the exception of the one who was on the rail, had arms and legs intertwined in each other with umbrellas, you know, in between them and the officers, preventing their arrest.
And when you stated that these guys use this black bloc clothing in order to conceal who they are, when defense counsel was asking if you personally saw this defendant throwing the incendiary device, are you able to say that, are you able to point out one particular individual as the person throwing the incendiary device?
No.
Why is that?
Because of all the umbrellas, the light clothing, all of the group working together to conceal that person's identity.
And was the defendant part of that group?
The entire time.
And when you were asked on cross-examination as to whether or not this defendant, whether or not you saw this defendant pulling barricades into the street, you stated no. If you can't identify them because of this clothing and the way that they're dressed, is it possible that she was one of those individuals?
Absolutely.
And when you guys were following these individuals, did the defendant ever step aside and say, hold on, I don't want to have anything to do with this?
Nope.
And from what you were observing that night as well, what you were observing that night, were they working in concert throughout the moment that they stepped into the streets and started to walk down Washington, blocking Washington?
Absolutely.
And using these the smoke bombs, is that a way for, I mean, your training experience, a way for these guys to force you guys not to be able to see them?
Yes.
Judge, if I may have a moment.
Sure.
Hi, Judge. Just briefly, at this time, the state would move exhibits number 2 and 3 into evidence, and the state would ask that the courts, they're authenticated with the seals, the whole 9
I
yards.
have no objection, Judge. Ms. Sponsel showed those to me prior to.
Exhibits 2 and 3 are admitted into evidence.
Hmm? All right, Judge, I don't believe I have any further questions.
May this witness be excused?
Yes.
Thank you, officer.
Thank you, Your Honor.
Counsel for the state, any further witnesses?
No, Your Honor.
Counsel for defense, any offer of proof?
I do have an offer of proof, Judge. I have interviewed 2 individuals who participated in this incident because of ER 4.2 and their concerns of the state charging them with offenses. They're not coming forward. I've referred them to counsel. However, the 2 individuals I did interview would testify at trial that they were not aware that smoke bombs or smoke devices were deployed, and individuals within the group were not aware of that. They were not aware of any weapons at the scene, and they did not make any threats of violence or use force of violence in this incident. So that would be my offer of proof from 2 individuals who are not, who were present at the protest, and the protest was for Black Lives Matters, but obviously they don't want to be charged and lumped in a group like my clients do.
So basically, counsel, you don't have an offer of proof to give to the court today with any names or testimony?
No. I mean, my client would testify consistent with that as well, that she wasn't aware that smoke devices were deployed. She did not move any devices.
Are you going to put your client on the stand?
No.
Okay.
No.
All right. Counsel for the state, any argument?
Yes, just very briefly, Judge, with regards to the elements of the offense of riot, the state would submit to the court that proof is evident, presumption great, that the defendant did participate in a riot back on October 17th of 2020. Not only did she participate in this riot, she was a active participant, as Sergeant McBride testified to. Sergeant McBride provided information that during the interviews they had learned that this defendant was in fact the one that provided the incendiary devices that the court was later able to see that were used against the officers, showing a sign of force against those officers. That force not only began with those smoke bombs, but it continued through whenever they were throwing the barricades out into the streets and blocking the officers from doing their jobs. And frankly, creating a substantial risk to these officers, as testified to by Sergeant McBride. The court heard that at least one police vehicle was made immobile by the defendant and her accomplices' actions, including officers having to get out of their patrol cars, again subjecting them to further potential of physical harm by having to remove these barricades out of the street. Furthermore, the defendant and her accomplices continued to use force against the officers whenever they got to the light rail tracks, where they yelled out that they were going to take the tracks, and that's where the group moved. This is the very group that the defendant was arrested in. Under the elements of riot, the state has to prove that requires proof that the defendant, while acting together with two or more persons recklessly used force or threatened to use force or violence, and if such threat was accompanied by immediate power of execution which disturbed the public peace. The court has heard testimony with regards to every single one of the elements for riot, and including the defendant's actions of providing the incendiary devices, as well as participating in the walking down the street and not giving up whenever the officers went to go arrest them. I would like to point the court to State v. Garland, 157 Arizona 246, in which the court, hold on 1 second. There you go. That is a Court of Appeals opinion from 1988, where the court held that a person must distance himself. A person must distance himself from the assembly when anyone in the group manifests an intent to engage in unlawful conduct. Failure to do so results in knowing participation in an assembly which is creating an immediate danger of damage to property or injury to persons. And in this particular case, it was a riot that the court was addressing at a jail facility. So with that being said, Judge, the state feels as though that there's proof evident presumption grade that the defendant participated and knowingly participated in the riot that occurred in downtown Phoenix on October 17th of 2020. The state would also submit to the court, contained in Exhibits 2 and 3, that the defendant was in fact on release under CR 2020-132033-001 for the crimes of aggravated assault. A Class 2 dangerous felony is one of the crimes. And she was arrested on August 23rd of 2020. She had her initial appearance on August 24th of 2020 and her not guilty arraignment on 9/8/2020, therefore showing that she was in fact on felony release when she committed these new felony offenses. If I may have a moment. I have nothing further.
And counsel, do you have a copy of that case law for the court to review?
Judge, I can email it to Your Honor as well as defense counsel.
That is fine, thank you.
I have, Garland.
Counsel for defense, any argument?
Well, Judge, I certainly hope the state's got more evidence at trial, because this is a very, very weak presentation. I don't even think it rises to probable cause. First of all, Garland is a prison case, so Garland is really inapplicable to here, where someone has a First Amendment right to peacefully assemble and protest, which is what was going on here. I think the best instruction how the court should approach this is a case out of the District of Columbia, 565 F. 2nd, 94, 2008 case, talks about rioting and how the court should look at probable cause, or which would be akin to whether or not my client's entitled to a bond. That was a rioting case, although that under their statute you need 5 or more. Here it's 3 or more. But that case is very instructive, and that's why I asked the officer the questions that I asked him. It's well established that in order to hold somebody non-bondable and have evidence, proof, evident presumption, great, that evidence must be an individualized evidence. You can't just say the group. This is what they did here, and say, well, she's part of the group, but they have no specific evidence or testimony regarding what she participated in. I'd ask the court not to consider this so-called evidence of other people who are arrested who are trying to say that my client provided them with these devices. One, they could never avow that those persons are going to testify at trial. They're defendants. So that's one. Two, my client's not charged with conspiracy or alleged to have participated in a conspiracy because she didn't. So that's not evidence. That's not, even though hearsay is reliable, I mean, hearsay is admissible. It has to be reliable, credible hearsay. And the officer admitted that those individuals who get arrested oftentimes blame others to try to absolve themselves. And in this particular case, the officer is very clear. He has no evidence that my client threw smoke devices. These were not, they say they're incendiary devices. They were not incendiary devices. They were smoke bombs. No evidence that my client, credible evidence my client provided those. No evidence that my client threw those. No evidence my client was aware that they were deployed. None. Other than this group speak that the officer's presenting to the court. So the requirement that that the conduct to provide proof evident presumption great must be individualized, cannot be undercut by pointing to the fact that coincidentally there was a group doing this. This is discussed clearly in Carr versus District of Columbia. They must show that they have this evidence for each individual. The fact that rioting is a group offense does not eliminate the constitutional requirement of particularized suspicion of guilt. It has to be individualized. Now, in this particular case, and this Carr case also talks about this, that, oftentimes the state will try to say, well, there's a group and they're moving together. But this case addresses that. It specifically says they have to be participating in destructive acts by individuals to be considered group acts. The video is very clear. The other individuals don't even see the people deploying these devices. And it's certainly not clear that my client was aware of those, and the evidence that they're trying to bring out that my client provided those, no receipts, no where she got them. And by the way, when they arrested her, no testimony that she had any devices on her. She didn't have any of that stuff. She wasn't aware of that. Now, they charged her with walking in the street, which is a misdemeanor, but we're not here on a bail hearing on that. They've charged her with unlawful assembly, but we're not here on a bail hearing on that. We're here on a bail hearing for rioting. A person commits rioting if, with two or more other persons acting together, such person recklessly uses force or violence or threatens to use force or violence. They presented no evidence that my client, well, they've admitted that my client didn't threaten violence. They've admitted my client didn't use violence. They said that somebody threw a smoke bomb, but they've admitted they have no evidence that my client participated or was aware of that. They talk about these barricades. They have no evidence that my client was aware of that or participated in that. Nothing. We have 8 minutes of video, the best they got, and you don't see one person or one incident on there where they can identify my client. And it's not hard to identify my client. I figured out who my client was within a minute of that video. It's not that hard to figure her out. She was in the back walking in the group, and she wasn't doing any of this stuff. And then they go to the arrest, but the arrest is not rioting. It's an arrest. Either they arrest her or they don't. Either she resists or she doesn't. They didn't charge her with that. So anything that happened at the sidewalk once they got off the street, that has nothing to do with the charges here, Judge. They simply come in here and they lump things together. They don't particularize it, which the Carr case says you have to do. And they don't show that my client had any knowledge of this. Now, Garland would come into play if they had evidence that my client had knowledge of this, but they didn't present any of this. These were, and you can see on the video, one person throws these devices, he conceals that he's doing it, and he throws it out. My client never saw that. And there's no evidence that my client participated in that. So based on that, Your Honor, on this particular charge, the court has to provide a bond to my client. Because you can't go to trial and say, oh, well, she's in that group, she's guilty. Our Constitution doesn't allow that. And I guarantee you when they come to trial, they're not even going to try that. They're going to try to find out how they can pin this on my client because they don't have anything right now. Nothing. And so she's entitled to a bond because she did not, being present, having no knowledge of this, not making threats, that is not proof evident presumption great of participating in a riot. And based on that, she has to have a bond. Thank you, Your Honor.
Counsel, can you provide the court with a copy of the case law that you?
I can let them make a copy of this. I mean, I have highlighted in yellow, but I have some check marks. But if they can make 2 copies, I'll give one to you and one to Ms. Sponsel.
Will you please do that for me?
Actually, you know what? You keep that. I'll email. I have this on my computer. I'll email it to Ms. Sponsel. Okay. I apologize.
Ms. Sponsel, do you need to see it before you do your rebuttal argument?
No, Judge, I do not.
Okay. Go ahead.
Judge, when we take a look at the case law that's controlling in Arizona, the case law that's controlling is the Garland case. I appreciate defense counsel bringing the state as well as the court's attention to the Carr case, but again, that's in a completely different jurisdiction with completely different elements than what we are looking at here. Defense counsel made several different arguments about my client didn't see this, my client didn't do that, my client. This is all mere speculation and evidence that has not been presented to the court for the court to take into consideration, because the defendant did not get up on there and up on the stand to make those types of statements. What we have here is we have several individuals that are charged with rioting under accomplice liability. For the defense counsel to make an argument that his client did not know what was going on would have to be akin to her putting blinders on and not being able to see anything that's in front of her, to the side of her, to the back of her, with regards to what was going on back on October 17th of 2020. The defendant walked down the street with this group. She's dressed in black. She's participating in every way, shape, and form. When we talk about, even though we don't have to talk about individual particularized conduct, we do have that from her. We have her walking with the group. We have her wearing the same clothing, which is used to conceal their identity, not only from members of the public, but as well as police officers. We have her, and the court can give it as much weight as the court possibly wants to give it. We have another individual stating that it's this defendant that provided the incendiary devices. The incendiary devices that were used as a threat, a force against the officers, along with the barricades, as well as the members of the groups using the rifles the rifle specifically, because it was known to the officers whenever they walked up. So with that being said, Judge, again, the state has proven proof evident presumption great under the Arizona statutes with regards to 2 or more persons participating in conduct that would constitute a riot under the Arizona revised statutes relating to these offenses, and that the defendant was, in fact, an accomplice to these, as shown. So with that being said, the state would request that the court continue to hold the defendant non-bondable, as there is proof evident presumption great that the defendant did, in fact, participate in this riot.
Thank you. Counsel will give me a moment. I'd like to quickly review the case law.
Go ahead.
Judge, I'm going to let Ms. Carter finish this hearing because I got to be somewhere in 40 minutes, and I can't be like,
Okay.
it's a parental issue.
I figure.
Oh, yeah, right there. That's all right. I can't be late to where I got to go because of COVID. All right, I'll call him.
court believes the court did review State v. Garland. The court did also review the pertinent parts of Carr versus the District of Columbia. The court has listened to the testimony of the officer that was there that day and did review the video shown in open court. While the court does believe that there were acts that may have been felonious that occurred that day, the court has to look specifically at the riot statute. In that riot statute, the pertinent parts that were argued is we know that there were 2 or more persons. We can see that clearly on the video. The court is focused on recklessly did use or threatened to use force or violence, which threat was accompanied by immediate power of execution, which disturbed the public peace. There was a mention of throwing incendiary devices, which caused smoke, which obscured what the officers could see that night. The court paid particular attention to where those devices were thrown. I believe the first one was thrown straight up in the air and came down almost directly behind the protesters. The other one was far off to the side. The court did not see any of those devices thrown directly at officers or at officer vehicles. The court also has to look at what was going on during the protest. What the court saw on the video was walking down the street, obviously trying to obscure the police officer's vision, which the court can conclude would be a dangerous situation for law enforcement. But the court also has to look at, was that a threatened use of force or violence? We are an open carry state. You are free to carry a gun. That may be threatening to other people, but it is your right in Arizona. This defendant did not have a weapon on her that was seen by any of the officers. When the court reviewed Garland, in that case, Garland had in his hand a chunk of concrete where something had been broken. We don't see this. Yes, there were barricades that have been damaged, but the court does not see the actual protesters damaging the barricades. I see them removing them and moving them into the roadway, which was an obstruction, but the court does not believe that that was a threat of violence. Based on this information, the court does not find proof evident, presumption great, that a felony was committed while on release. Therefore, the court is going to set a bond. Counsel for the state, do you wish to be heard as to the amount of the bond?
Your Honor, the state is requesting that the court set a $100,000 bond with regards to this particular defendant. She is transient. She does not have any known address of where she is going to be living, and frankly, she is a threat to our community. She's a threat to the officers out there in the street. She's a threat to regular, normal members of the community. The state respects the court's ruling with regards to the court's ruling that there was no force. However, with regards to the amount of traffic that was diverted, people on the street that were diverted, and by the mere fact that these individuals were planning on taking, including the defendant, taking the light rail track shows that she's a danger. Furthermore, she was on release for a dangerous offense. She had, in a previous occasion, where she had an umbrella with a sharpened tip on it sliced the hand of a Phoenix police officer who was trying to arrest. On the date of that offense, she was found with bomb-making materials, i.e. acetone, rags, lighters, things that are available for making Molotov cocktails in her possession. So with that being said, the state feels as though that a $100,000 bond is appropriate, and furthermore, with regards to the testimony, I'm sorry, not the testimony, but with regards to statements made by other individuals in this group, this is the defendant that organized this. This is the defendant that provided the incendiary devices. This is the defendant that wanted to use the violence against the police officers. So with that being said, the state would request that a $100,000 bond be appropriate with regards to this defendant.
And counsel, just so that I'm clear that I'm looking at the correct release conditions, in the case where she was on release to pretrial services without a bond in place?
No, I believe she had a bond in place that was posted.
Judge, she was released OR in that case.
Actually, I believe she was released PTS.
Okay, I wasn't sure.
I'm looking at this and it says supervised release pretrial services, so I wanted to make sure that I understood.
No bond.
That there was release to pretrial services in that case and there was no bond set. Anything further, counsel, for the state?
No, Judge.
Counsel for defense?
Judge, we would argue that $100,000 is just the legal price for a Class 5 rioting charge. As the counsel for the state pointed out, her original protest charge, she was charged with a Class 2 aggravated assault with a dangerous instrument, which they are alleging was wrong. That commissioner found it appropriate to clear up pretrial services and did not impose a bond. So the idea that $100,000 bond for a Class 5 felony does not comport. As far as the providing evidence, they provided no evidence that she organized this. They provided no evidence that she purchased the smoke bombs. They provided no evidence that she knew or should have known that these devices were going to be used. She was participating in a demonstration in Phoenix, exercising her First Amendment rights. They cannot identify her particularly as committing any of the offenses that they are alleging were committed by this group. We would ask that Your Honor set a bond that is commensurate with a Class 5 felony in the amount of $3,500.
Thank you. And based on the information presented, the court is going to set a bonding in the amount of $5,000. That will be a secured appearance bond. You are not to initiate contact with the arresting officers. You are not to return to the scene of the alleged crime. You are not to initiate contact with any alleged complainant or witness. You are not to initiate contact with any alleged victim or victims if there are any named. You are not to possess any drugs without a valid prescription. You are not to possess or consume any alcohol. You are not to drive a motor vehicle without a valid driver's license. You are not to possess any weapons. You are not to leave the state. You must continue to provide the court with proof of your local address. And do we have dates set for her already? Okay, so it looks like we have an arraignment hearing set for November 3rd. Is that correct? Yes, okay. And is that at 8:30? And then there's a status conference on November 30th, and who's that in front of?
Judge Moskowitz.
Okay, before Judge Moskowitz. There will be an initial pretrial conference again. Is that going to be before Judge Moskowitz as well? Or it's going to be before Commissioner Allen on December 18th at 8:15. And then the comprehensive pretrial will be back before Judge Moskowitz.
I'm actually going to go back and read that.
Okay. Ms. Sponsel, is the other case before Judge Moskowitz?
I have the other related interest,
So it needs to stay there.
NPA basically said all of these preemptively. Yeah, we need to be swapped over.
Okay. So they will all be set before Judge Moskowitz.
I'm going to actually, I'm going to email NPA. The NPA date and the status are probably confirmed.
Okay.
I'll let NPA know that they need to reset all the other dates.
Yes. Before Judge Moskowitz. We'll make sure that that is correct. Because it looks like she's before two different judicial officers. All right. If there is nothing further, thank you everyone for your time.
Thank you, Judge.
Ma'am, you'll need to come and sign for your terms and conditions or your rights to release.
Yeah.